or licenses which actually do something which we call trump the exceptions. Now, the environment in which we're working in is one where we think we've seen far more emphasis on enforcement than we have on dealing with things relating to the public interest. When it comes to exceptions to copyright in the public interest, we've seen just one international treaty benefiting users in the last century, and this compares to 8 international treaties that benefit rights holders. So when we consider that more and more materials in library collections are in a digital format, we think that copyright laws are actually outdated and are increasingly preventing us from doing our job, simply because we've now moved from print to digital. Turning to creators and users, I'm also not sure that the current system fits the bill. The digital environment is changing user expectations, and when I have my user hat on, when I want to pay for some music and I'm trying to hand over my money to a major corporation or a small indie label, I find it extremely frustrating that the music I want to buy is suddenly not available in my country. As an internet user, I know that this product, which I also know is not being sold to me, I know it's being licensed to me, is basically zeros and ones, and the technical responsibility to educate people about copyright. And I want to utterly stress that we want to be the most law-abiding citizens on the internet when it comes to copyright. But if we're unsure that what we're doing is legal or not, we're in a very difficult position. So the bottom line is that we feel we can't confidently share materials across borders, and this to me means we can't confidently take advantage of all of the information dissemination activities that the internet offers us. So it's not really just enough to complain about a problem. I think it's always quite useful to propose a solution. So IFLA is working at the World Intellectual Property Organization, and we have proposed an international treaty on copyright exceptions and limitations for libraries and archives. Now, this is a piece of work which we've been working on now for about 5 or 6 years. Those of you in the room who have followed the negotiations that led to the Marrakesh Treaty for the visually impaired know that your hair colour can go from full black to total grey in the time it takes to actually get a treaty resolved at an international level. You can also possibly acquire heart problems, lose friends, and discover a whole new way of, well, international treaty making. What we're proposing is that there's an international treaty put forward for libraries and archives that establishes basic international standards. I mentioned earlier on that we operate under a patchwork of different laws around the world, and we don't actually have the unique role of libraries and archives recognised in national copyright systems around. So we would want to introduce basic global standards for the functions of libraries and archives, and to permit libraries and archives to operate across borders. We want to ensure an equal treatment of digital resources, and we want to ensure that through the instrument, copyright laws that protect the use of traditional formats such as print in libraries and archives also applies to digital. We want to protect the ability to acquire and to lend our digital collections. This is a huge issue for us. We don't want lending of materials to stop just because we've moved to a digital age, which means that we would try to make sure that we are not refused the opportunity to buy or lend commercially available e-books, for example. And then we would try to make sure in this instrument that we could safeguard our cultural and scientific heritage. We would ensure that libraries and archives can legally save all materials, whether they were born in traditional formats or whether they were born digital. And then the other major thing we would seek to achieve is to unlock orphan works. We have tens of millions of high historic and educational value works which are held in our libraries and archives, but they're unavailable to the public because the copyright holder cannot be identified or found. So we would use this instrument to mean that libraries and archives can make orphan works available for socially beneficial purposes like research. We don't think that these are too big an ask. We can't do many of these activities yet, particularly not cross-border, and therefore we're proposing that WIPO member states move forward with this, and we think that that could be libraries and archives' contribution to a future-facing copyright. So I'm going to leave it there. I'm sure there's going to be questions, and thank you very much.
Most of the content is protected in ordinary life and by the ordinary law. They're creative works. artistic works, movies, songs, and authorship, etc. So we tend to focus on copyright as protecting these on the internet as well. And the point, I only really want to make 2 points today, and the first is that historically copyright has been quite good at adapting to the new technology. I'm going to finish, of course, with a problem area, but let's look at what it's done well. First of all, and particularly in my country, but I think in many countries like mine, the law was originally reasonably technology neutral and adapted quite well, so copying was copying whether it was done by a photocopier or by a fax or eventually by the internet. But 4 specific examples of the way that law responded as it had to the phenomenon of the internet, and others may talk more about that. And the first was this point about copying by browsing. And many of you will know that, in fact, approximately 7 copies of any particular work are made in the course of transmitting a document from one computer on the internet to another. By the time you look at the copies made by the routers and by the ISP and by the video card in your laptop and then by the display on the screen and so forth, there are actually 7 copies of a work made. The way the law responded to that in most countries that I'm familiar with was pretty much the same. And eventually, and there were cases that went to quite high levels on those issues, that was decreed at the end not to be a copy. That was not an infringing copy, and the way that the law dealt with that mostly was by saying it wasn't sufficiently fixed. You know, to make an infringing work, you actually had to make something, and so some cases say, well, this isn't really making anything. And some cases, and I'm familiar with some of the US ones, said it's not made for a sufficiently long time. This is not an enduring enough work to be an infringing. And in New Zealand, we call that an ephemeral copy. It's only here for a short time. So most copyright law responded to the browser situation by saying, well, it's a copy, but we're not going to make it an infringing copy. Another area where the law responded was the safe harbour concept for ISPs. These are people who are doing good work, they're bringing more people on the internet, they're providing a service, and somewhere in the course of that, in their machines, put there by other people, can be found infringing works. So most jurisdictions work quite hard to make sure that ISPs either were not liable at all or had liability but could lose it if they didn't perform certain conditions. Now, there's a continuing struggle in that area as to when an ISP or another provider in the chain might lose that current protection. And we've seen different systems develop where the ISP has to give notice, or notice and notice, or notice and takedown. And this is a developing area of the law, but I regard it as an area where the law has responded reasonably well in terms of the concept that ISPs ought to start with a presumption of protection which they may lose. My third point would be the recent Google victory in a long-running case involving taking snippets of digitized books and presenting them as part of the search content. The judge in that case said there were many things very positive about Google Books, and I don't know whether everyone's familiar with it, but it's a wonderful research tool. And more particularly that this did no harm to the copyright owner to have this material made available for searching. And my final point starts off by being almost a joke, and that's that chimpanzee selfie that many of you will have seen. We saw a picture of a chimpanzee, a photograph of a chimpanzee taken by the chimpanzee, and it provoked...
It was an ape.
An ape, I'm sorry. As a zoologist, I should have got that right, I'm sorry. I just read the Huffington Post, I probably should know. So the question was, who owns the copyright in that picture taken by that animal? And eventually the decision in that jurisdiction was that it's in the public domain. And that actually is an indication of a slightly more complex problem, and that is the authorship in other circumstances when there's a direct human agency. And we've had to deal with the circumstances where copyright works are authored, music is written, etc., without any apparent... So I point to those as being examples of how good copyright has been typically in responding to the challenges that internet brings. Excuse me. But there are other sides to that story, and I think it's probably worth reflecting, first of all, that if there hadn't been that accommodation, copyright had the power probably to kill off the adoption of the internet in the early days. Remember that copyright law was actually invented in the United Kingdom, not as a result of the pressure from authors for the right to control their work, but as an extension of state censorship law. If we go back to the Licensing of the Press Act in 1662, you see that stationers and printers were authorised to record all books printed, to burn books when they found them that weren't entered in the index, and to have the only right to print and publish. And this was the state's method of controlling this growing and dangerous industry of printing, which was committing the sin of presenting information to the public. And the roots of that legislation go back to the British Star Chamber, about which you may have heard, not a pleasant history, from as early as 1637. So that act was repealed eventually in 1694, and the printers clamoured for it. Printers, not authors, wanted that kind of statute back. The authors didn't really want it. So it took some time until the printers went back to the law and said, we need to protect the authors. And they managed to get an act through the British Parliament in 1710, and the reports of that at the time are the stationers knew quite well that they should be supporting authors' rights, because the only thing the authors could do with those rights was then sign them over to the printers, because the printers had all the power. So it's important when we're thinking about copyright to recognise that there are competing interests. There's history to this. And it's still very much part of the distributor's model and part of the distributor's weaponry that we have these copyright disputes. What's interesting is that many music and other artists are developing new internet distribution models that cut out the middleman, the distributing chain. And the thought I want to leave you with is really what the internet has done to disturb, if you like, the original bargain that lies at the heart of all intellectual property monopolies. The idea of an IP monopoly, and it's the same for patents and designs, is that the state will give you a period of reward where you have the market to yourself as an incentive to creativity, to reward you for creativity. But there's a balance. You don't get it forever, and you're not entitled to make gross profits at the public expense. So consider that there are, in the US alone, one of the major book publishing markets, between 600,000 to 1 million. What the internet offers is access to 100 million customers. So what we tend to see happening is the copyright owners and the distributors saying, well, the same work must be now worth $500 million. The same work that was worth $100,000 under the previous model, because of the huge increase in availability that the internet provides, they say that work is worth $500 million. And yet the work is the same. And not only that, the market has changed. So what should a fair return be in these circumstances? What price should the author pay for the vastly increased reach at no additional cost? Who gets credit for the cost savings with the no staff and not having to pay for shelf rental and pay for transport and insurance and all those other things? So I think that's the point I want to leave you with. Whereas copyright law has been very flexible in some ways, developing a new distribution model and a new pricing model which reflects the vastly different market is something that I think we've yet to grapple with, and we as a society need to think through. Thanks.
Well, thank you, Peter. Very interesting thoughts, and especially because of the ape. It was an ape, right? I mean, it wasn't a monkey. So we need to respect the authors and even the apes. But I will leave to Linda then. Thank you, Linda.
Hi, my name's Linda Kinney. I'm here on behalf of the Motion Picture Association. And sort of a funny story, I ran into a former colleague of mine. My background is actually in internet and tech policy, and I spent over a decade at the Federal Communications Commission working on broadband deployment and universal service and trying to get broadband out to rural areas, to people who don't have access to it. So that was 20 years ago in the US, and I feel like 20 years later we're now talking about the same issue, only with countries instead of the United States. So I ran into a former colleague of mine who, there's a competing panel right now on net neutrality. And they said, oh, are you coming to the net neutrality panel? And I said, oh no, I don't do that anymore. Oh, you're so lucky. So what I didn't say was that I was representing the entertainment industry on a copyright panel. So I avoided that. Small fact. So anyway, I'm excited to be here. This is a terrific forum. I think it's a great chance and opportunity for all of us to have a discussion. And to be honest, I think everybody at this forum has the same objective in mind, which is to see broadband deployment pushed out further and further, and really access to broadband throughout the world. It's great for the entertainment industry, but it's also great for every government because it facilitates economic growth, and it's terrific for people who want access to information, people who want to share information, I think NGOs. The digital economy has been really transformative, and I like the fact that this is an opportunity for us to get together and work together on best practices and ways to accomplish what I think really is and should be a common goal. That said, we are on a copyright panel, and so I was asked to address a few issues, one of which is what has the impact of the internet been on copyright law, and also whether there are some new players now as a result of the internet. And there's no question that the internet and broadband deployment have really changed the world in a whole new way, particularly for the entertainment industry. We have a new distribution platform, and it is very hard, it's very difficult for an old law that was written at a time when you're talking about physical copies to then have that law actually applied in a digital context. But one of the things I learned a long time ago as a public servant writing statutes is you are never going to be ahead of technology. I mean, that's just never going to happen. And whatever law we pass now needs to be flexible enough. And I was actually very happy to hear Peter go through some of the ways that copyright law has adapted in this new environment, because I think we all owe it as a society together to try to figure out ways to get that balance right and support both creators and creativity, and also this new world that gives everybody access to information and spurs economic development. So one of the questions we were asked as a panel is, who are the new players as a result of this internet, this new development? And I think there are new players in the copyright world. From our perspective, starting with there are now intermediaries that have been brought into this conversation. And that is a result in part by one of the things the internet does, which is facilitates easy copying of digital works. And what we are seeing as an industry, and we deal with it every day, unclear how much the average population knows about it, is criminal enterprises that develop as a result of the internet and are able to hide. And so they can go to different countries, they can buy servers and deliver their content across the world, they can engage in unlawful activities, and it's not just our content, it's child pornography, and we've been talking to a lot of different groups, NGOs too, on some of these issues, and we all face the same problem. You have a criminal enterprise, and mostly it's because the people can remain anonymous, and that just doesn't work in the physical world in the same way. So that's a new group of players. As a result, we also have a new group of intermediaries that are involved in this issue now, and that's the broadband or the ISPs, in addition to search, and there are several other registries are another one for those of us who work on ICANN issues. And because it's so difficult for us, and again, when I say us, I don't just mean copyright owners, but also child protection advocates and people worried about the financial industry, financial fraud. These are all things that governments and people really care about. It's very hard for us to track and to capture and to deal with those enterprises that we cannot find access to, or who just jump from country to country whenever there's a takedown notice. So it's a big challenge for us to deal with. So that's kind of the second group of new players that has emerged that did not exist back in the physical world in the same way. And the third, I would say, is user-generated content. Again, the internet, digital technology, it's enabled all of us to become users, creators, and it's been really phenomenal. Even our industry has been in awe of the stories and the films that are made by people all over the world, that are created with sort of very few resources and little equipment, and the creativity that's inspired. And in fact, this goes to, I think, something this forum does really well. I've been to a lot of different workshops on local content, generating local content, which is critical. As we know, there's a virtuous cycle between the internet and content. Nobody is going to buy a tablet just for email. You're going to buy a tablet because you want access to content. And the other thing we know is international content is not enough. I think every single person in this room wants access to both local content in their local language, and they want access to international content, whatever that content may be, or somebody they follow. So you have to have both. And especially in the emerging world, we have this challenge because it's difficult to get financing. There are lots of different barriers, actually, to developing that local content. But I think a lot of our members are stepping up to the plate and going into these emerging economies and trying to hire local developers, local writers, local directors, which provides jobs and creates content. Why? Because people want that. Like I said, it has to be both. And it's, and frankly, those people understand their culture. They understand the inside aspect of what people in that population are interested in. And I would really like to hear, hopefully there are some producers of content that are local producers, either here in Istanbul or in other emerging economies, and can tell us about their experience both with developing that content but also with copyright and what role that plays from their perspective. So I think a few of the things that we've talked about at the IGF in terms of these challenges to local content are, number one, having an environment that supports free expression. Oftentimes, an environment that supports free expression will also have strong copyright laws. Those things go together because you have rule of law in a more lawful environment. And I was fascinated to hear Peter's story, actually, that it was protecting the censorship. I did not know that fact because America didn't exist back then. So we didn't learn British history in America, it turns out. So I think we also know that you need an environment that it's a trusted environment, and we are hearing and finding out that that is more and more important throughout the world. It's something that as new countries come online, they're discovering themselves. And when I say a trust environment, part of that is strong consumer protection laws. And it may be privacy has become a really big issue in a lot of countries and in Europe. People want their privacy protected. They want to ensure that their bank accounts are not going to get hacked, that there's not malware, botnets that are going to infect their computers. I mean, these are all new issues that we just didn't deal with as a society 20 years ago. And it has to be that there's a certain level of consumer protection and law enforcement that backs up the internet and creates a trusted environment in order for these countries even to want to adopt or people to get online. And I think the last thing I'd like to mention is digital skills. And again, that goes to this issue of developing local content. The more people have digital skills, the more access they have to information, which is one of the goals of the IGF. Also, they're able to create content, they're able to share content, and that's an area where we, the entertainment industry, as well as I think everybody in this room, can get behind and support best practices for promoting digital skills, and especially these emerging economies. Yeah. So I've been told that my time is up. I will now pass the mantle.
Thank thank you, Linda. I think it's very important. I mean, the idea to have these new players around, I think, raising very important questions that we didn't realize it was important in the past. And the other thing important is maybe to think a little bit about what is the role of the copyright. And you raised that question. I think it's very important. The role of copyright for the creation of content. I think that's an unanswered question yet. So, Konstantinos.
Thank you. Hello, everybody. My name is Konstantinos Komaitis, and I work for the Internet Society. And for those of you who do not know what the Internet Society is, very briefly, I will explain that it is an organization established in 1992, and with a very basic but very important mission, as far as I'm concerned, to make sure that the Internet is accessible by everyone around the world, and that the Internet's underlying design and architecture maintains the same. Continues to be the way it was originally designed. So the Internet Society was essentially created to provide the institutional home to the Internet Engineering Task Force, the ITF, and this is the body that creates the Internet standards. This is the body actually that creates the Internet. So here we are again. I feel that, you know, this issue is recurring. I have been coming to the IGF for the past 9 years, and there is always a copyright stream. But I am feeling over the years that the discussions actually progressed, and we've come a long way. I think that where we started and we all accept right now, and we should accept how important and vital copyright is for everybody, and the choices also that copyright provides to content creators. We also see more stakeholders engaging in discussions of trying to understand the role of copyright law, and especially the nexus that copyright has with the internet, and how the internet affects copyright, and how copyright affects the internet. So content is king, and everyone is a creator, and this was, I am borrowing a title that a couple of years ago was a topic of discussion at the ITF, and I see Glenn Dean down there, who has been doing great work in actually trying to adapt technology and trying to understand this relationship that exists between copyright and the internet. So I used to be an academic, and my PhD was actually investigating this relationship between those two, what appeared to be at the time, and for many, many people, conflicting things, but they're not conflicting. They actually walk hand in hand, and one can facilitate the other. Linda, I think, and Peter, and as well as Stuart, really pointed out to the fact that there is this stream between copyright and the internet, and over the years we are moving closer together in actually identifying the commonalities and how one can help the other. We see new business models emerging, but we also see traditional models not only adapting but you know, occasionally even thinking outside the box. We see how the relationship between the new business models and the existing business models it gets tighter, and the marriage gets much better. And I'm thinking right now, you know, Netflix and how it is being used as a distribution channel for traditional business models, and who are able, and for many people, to get access to content that we all read and we all want to get access to because of the internet. And in talking to, I have been talking to various studios and content owners, and one of them said something to me which I loved, and I have been quoting ever since, that the internet might be disruptive, but it's not destructive for copyright. And I think that this encapsulates perfectly the challenge, but at the same time the opportunities that are being presented to all of us to move forward and understand actually what are the best ways in order to make sure that we use this opportunity in order to have a copyright regime that is adjustable to the internet and having an internet environment that understands the copyright regime. So one of the questions that we were asked to deliberate on is, for example, whether we see any new methodological approaches being developed to address those copyright challenges that have emerged because of the internet. And I think that Linda nailed it when she said, you know what, I've learned very early that, yes, law cannot catch up with technology, and it can't. I mean, Stuart mentioned 14 years for an international treaty and 5 years in the making and discussions for another treaty. So what we have seen lately, and I think it's a very interesting thing that is happening, is that key players are taking the initiatives, voluntary initiatives, self-regulatory initiatives, to try to address these challenges. Are they perfect? Perhaps not, but they are definitely a great step and a very vital step towards identifying those solutions. We need to remember that those voluntary initiatives are part of this multi-stakeholder structure that we are all here for, to preserve and to encourage. For example, and I'm thinking about the copyright alert system in the United States was actually open to all stakeholders. It had content owners, it had businesses, it had civil society groups, the government was behind it, and so we see those trends emerging, and those trends can be very beneficial. Of course, there are basic principles that have to be based on, but at the same time, they can offer extremely valuable lessons as to how to tackle some of these challenging issues that we see emerging. So I will stop here, because then I will start repeating what other people are saying, and looking forward to the discussions.
Thank you. We've been hearing you a lot in the last IGF too, so I think it's all right. That's a joke. I think it's very important also to, I mean, the point that you raised regarding this relationship between the internet and the copyright, which is, of course, is something obvious, but I think it's important the idea of to think a little bit about how the both systems can understand each other. I think that's an idea that I think it will be interesting to just, go around later. So the last but not least, Mishi.
Thank you, Claudio. Just a little introduction. My name is Mishi Chaudhry. I am also a lawyer, fortunately or unfortunately, and my clients include the world's greatest free software developer projects, some of which all of you are using, or some products based out of on them. That includes Linux, Debian, Apache, or name anything, which runs sometimes in your cars, in your phones, and elsewhere. Also included in that are biggest content creators, some contributors, like to the Wikipedia. So perhaps those people have actually contributed to learning and dissemination of more digital rights based on minimal copyright, such as the GNU GPL, or the use of Creative Commons, which has led to way more creation of content than anything else has. We are these days living in an era of hyperactive copyright enforcement, scaled up, automated, and it is set to meet the boundless new capacities for free speech, assertion, also infringement on the internet. The opportunity to create is weakened in this current hyperactive copyright world. The creation requires permission, and creativity must pay a lawyer's bill first. Yes, the copyright law, which was made initially for the printing press, is not very well suited for this age. It needs a major rethink of fair use, penalties, and the duration of copyright protection. It needs to be more forward-thinking and flexible than ever before. In fact, getting rid of it will be perfect. I'll find something else to do. There are more interesting things. But honestly, any reform is impossible in the short term, because big content and the power of Hollywood will not let it happen. And it's inevitable in the long term because of the power of time and innovation. People are more interested in asserting the rights that they have against the so-called online piracy. The current takedown mechanism started with the DMCA in various jurisdictions, implemented very differently, and requires these rights holders to monitor sites for infringing content, a process which is never ending, a Sisyphean one perhaps, because the internet has grown. This requires reframing of the question itself, given the decades of the rhetorical entrenchment of the property rights and the law enforcement around it. As I said, we live in an hyperactive copyright enforcement era. All of this cry, it seems very, very far away from what were the original narrow purposes of intellectual property right. I practice in the United States, and I'm also an Indian, and I practice in India as well. Whether the children in India who are actually very, very excited now because education is not limited to the elite few and can reach anybody through this wonderful thing called internet. But obstacles of the Brahmins, which were earlier limited only to our country, have expanded everywhere. I also practice in the United States, where the Constitution, under Article 1(8) had given, which was passed perhaps the copyright law in 1790, had initially established a term for a 14-term protection. It was renewable for another 14 years. And where are we today? And where are the TPP discussions about the extension of the term of copyright today? Well, it's all a secret unless you check WikiLeaks. But it was all about short-term incentives. It was about weighing the state-granted monopolies against the natural condition of circulation of information. That time, the natural condition of circulation, as our great, not mine, but great founding father, Thomas Jefferson, had pointed out, was different. Today, it is a little different. That is why we are all here. Over the past century, everything has turned on its head. The prioritizations have changed. Public domain has been reduced to a historical artifact. It's out of date. Now we can challenge the imperfect control of the internet that enables piracy, but also allows a lot of free speech. Yes, there is a problem. You can solve it two ways. One, this is the major, biggest issue of the century. Let's have a new agenda, make it even more restrictive, more strong, enforce them strictly, put them all behind bars, and often presented as a fact. It's not well equipped. We need more through secret deals or other ways of negotiations, but we need more. Or there is a second path. We change the copyright laws to ensure that more of what we are doing these days, all of us, very, very naturally, this sharing, this creating every day, this new digital culture which is happening, is made legal. And we can expand the rights to reuse and remix copyright work in non-commercial contexts. We should think carefully also about its enforcement. Necessary and proportionate is not a word just for surveillance. Necessary and proportionate enforcement that will minimize harms to free speech and individual liberty. Yes, the price of the first path is our privacy. At least some of our new freedoms, the ones which are emerging because of internet. Our right to be producers, to be creators, users, as well as the consumers. The price of the second path is a destruction of kind, which we saw in the music industry at the turn of the century, which we are beginning to see in the TV, film, and the publishing industry. Yes, piracy is a part of this disruption, but it is just a symptom. It's not the cause. There is a different business model out there. The cause is because there is a decline in the cost of copying, of distribution, of making different copies, storage, and various other things. And this cause is internet. And this is the new condition, the natural one, which the Constitution was talking about. And again, it's time to weigh and balance it about the state-granted monopolies, about what is now the natural condition. Most copyright people, most people amongst us will enforce in general, will support copyright enforcement, but not when it will start and begin to compromise free speech through censorship and overblocking, or privacy through monitoring of our internet activity. Whatever you do has to be monitored in order to know what are you exactly doing. Let's recast this debate. We've seen the intermediaries. I do come from India, and there have been, at least in 2013, because blocking of websites is so secret and nobody tells us, but we did hear, at least our erstwhile minister tell us that 1,208 URLs were blocked, some of them for copyright, some of them to restrict what people didn't want to see. We've seen some instances where there have been handed out to suppressive regimes this way of restricting the free flow of information, and they are lapping it up, because isn't that what was sent to them or forced for them to be signed? Let's recast the intellectual property rights description. Let's rephrase all of this. Intellectual property rights, as perhaps some kind, they are government-granted monopolies. That's why they're jurisdictional. Let's see these restrictive laws. They're crony capitalism. And internet surveillance can only happen with a lot of digital surveillance. Sorry, copyright enforcement can only happen with a lot of digital surveillance. If we are all mindful of these, and we also see how the various intermediaries, whether it is your social media websites or your search engines or various other people who have been burdened with this duty to take down user-generated content, to monitor, and which forces them to err on the side of caution, because people like us are expensive and charged by the hour, and who wants to waste all that money? When small and medium enterprises are facing these problems, when innovation is suffering because the cost of entry has been raised to such a large extent that people find it very difficult to create, when people have to embrace other forms. Minimal copyright has served pretty well for free and open source software for 25 years. And it might all sound very drastic. Getting rid is not going to create that much of a trouble. We will live. But at least minimization and embracing of the current structure and editing it will lead us to a very different world. Thank you.
Thank you, Mishi. I think you raised a couple of very interesting issues regarding enforcement, for instance, and how the trade agenda, for instance, are trying to address that issue in a very complicated way, and how to connect somehow the copyright enforcement with the respect of other fundamental rights. I think there are a couple of very interesting ideas, but I can bet there's a couple of questions on the hall. Well, I can see that. So we would like to have some questions from the floor, and then we would like to hear if there's something about the remote participation with Andres Guadamos, our very best there. So, okay. I will need a mic, please. Do we have a mic? No? Oh, yeah. Wait. No. Okay. Thank you.
Thank you. I have a question about incentives.
Can you present yourself, please?
So,
can you introduce?
My name is Andrew Bridges. I'm from Fenwick and West in San Francisco. And I have a question for both Ms. Kenny and Ms. Chaudhry about incentives for creation. From the motion picture industry, we hear that there needs to be more copyright rights, more enforcement, and more production tax credits from states in order to incentivize motion pictures. The U.S. Chamber of Commerce last year blasted India, just blasted India for its insufficient IP enforcement and IP regime, and said that Bollywood, already the world's most prolific film industry, would suffer unless India increased its IP protection. But I believe that the United States produces about 450 feature-length films per year, and Bollywood produces about 1,500 per year. To what extent is it really true that Bollywood will thrive more if India increases its IP protection? Or can we explain the success of Bollywood by the relative lack of IP protection in India? Thank you.
Okay, I think I should.
First question.
No, it's
Okay.
And that's for
Sorry.
both Ms. Kenny and Ms.
Yes,
Chaudhry.
just wanted to respond to that first. I think one thing that's very interesting and a very useful tool that the IGF has done is put up some draft language, some draft reports online. And I want to get around to this Bollywood point because one of the comments that was posted online that I thought was very interesting in the local content section, because a lot of these same questions are asked. There was a study that was referred to by a Harvard law professor, that in fact was a Bollywood study. And there were some economists and statisticians who looked at Bollywood and were actually able to look at the data and determine that during a time when there was rampant piracy, there was actually less creativity. And so they found a connection statistically between copyright law and a stronger copyright law, and that it does, in fact, have an impact and effect on development of creative content. So I would refer you to that study that's referenced, again, on the IGF website by a Harvard law professor. And I think that's a very interesting, it's something that we've all been thinking about and really have thought for a long time. Again, there are some local producers, I think, here who may have their own stories, but there is an impact, and this study actually proves it statistically.
We're having more questions from the public, and then I will ask the panelists to just wait a little bit to just for a couple of words. So we have one question there, Ms. Can you please raise your hands? Okay.
My name is Julia Reda. I'm a member of the European Parliament for the Pirate Party. And I feel we have heard very different views on the relationship of copyright and fundamental rights. And Ms. Kinney, you said during your presentation that an environment of freedom of expression also has strong copyright laws. I would like to hear the panel's opinion on instances where copyright law is being used as a censorship tool. For example, in Germany, where I come from, an NGO has recently used freedom of information laws to obtain a government document from the Ministry of the Interior where the legal experts of the ministry were arguing that a law that was being passed was unconstitutional. And the ministry was arguing that this document, even though it was released under freedom of information laws, could not be published on the internet because it would violate the copyright of the lawyers working for the ministry, even though these lawyers are being paid by taxpayer money to be doing this research. So I would like to know what you mean when you say that copyright law and freedom of expression necessarily go together, and whether you can imagine instances where the opposite is the case.
We have another question there, sir. Yeah. Christiana? It's just, we have first there.
Hi, this is Burcu Kılıç from Public Citizen. Coming back to the trade agenda and the TPP, we've been discussing copyright agenda, multi-stakeholderism, and internet and copyrighted internet age. But I don't know how many of you are aware. But the 12 countries, the negotiators from 12 countries, simultaneously negotiating a free trade agreement in Hanoi now, Vietnam now. The negotiations have started, and they are discussing copyright enforcement, notice and takedown procedure for copyright infringement, and unfortunately, these rules will be regional rules for Asia Pacific for 12 countries for now, but it will extend to new countries. So I want to hear more about the trade agenda and more about the copyright and internet in trade agreements from the panelists.
Thank you. We have one question there. Yeah.
Thank you. London Internet Exchange. I've got a question from a business perspective relating to how copyright incentives can boost creativity in value add. I believe that it's very advantageous to us all if creators of original works and creators of added value can reap the benefits of investment in their creativity. And when it comes to piracy and the freely available infringing works online, those value-added platforms that provide a better user experience than the pirate platforms are very much, in my view, part of the solution to this issue. What concerns me is that in an environment where you have the exclusivity principle and the right to set your own price arbitrarily for your original works, those that add value to other people's original works have to negotiate for the rights to license that. And if you're successful and you make some profits, you would hope to make some return on your investment. But when the licenses expire, you have to then renegotiate that. And where there is essentially a monopoly seller, there is a strong ability to extract all the value that the value adder has created and pass that back to the creator of the original works. I'm concerned that this might create a structural disincentive to invest in value add in third-party original content. And the exclusivity principle there therefore has the potential to reduce both the diversity of such platforms and the ability to set prices at any rate that you choose without any form of sort of set pricing or regulatory oversight or whatever it might be, means that there is an ability to extract value from those that have been successful, thereby disincentivizing investment. I wonder, therefore, whether the exclusivity principle is still fit for an internet in which adding value to other original works is increasingly important.
Thank you. We have another question here. Please, the lady in white.
Well, it's actually not a question. It's more like as a comment. Copyright is I don't know. In Colombia, we have right now a case of a criminal case related with copyright, where a master student shared a master thesis on the net. And he is accused right now. He's facing a criminal process, facing up to 8 years of jail for doing this, which is showing that there is a clash among copyrights and human rights. The exercise of human rights is more or less like this is the daily things we do on the internet. We share things, and this is something that this student did with the idea of helping other colleagues at his university in the regions in Colombia, not in Bogota, not in the city, in the capital city, in the regions where libraries where you don't see that many libraries, where libraries has a lot of constraints on getting databases and getting licenses and so on. So we in Colombia are very concerned about the constraints copyright is presenting for the exercise of human rights, especially access to knowledge and access to information. Also, another thing that we want to discuss or to listen more about it is what are the reasons for the extensions of the protection of copyright terms. You know, what happened with that? What are the reasons for that? When we wanted to have more exceptions and limitations in Colombia, they are telling us where is the need for that. You have to show us proof for where are the exceptions and limitation needs. While for the extension of the copyright term, no one asked for that. It's easy to do it, just that.
Thank you. We have one last and then a round of our panelists. Here in the front, please.
Good afternoon. My name is Pranish Prakash. I'm a policy director with the Center for Internet and Society in India. Up until 2011, when there was an amendment in the Indian copyright law, search engines in India were illegal. In 2011, a specific clause was added to the law to actually make search engines legal and to allow for legality of what ISPs do. In the US, etc., there are in the fair use rights in US copyright law, things like transformative use have been read in. In much of the rest of the world, that is not the case. In the UK, private use, etc., still is very restrictive until recent amendments. So my point is that we can't have a US perspective of fair use for the rest of the world where those laws just don't apply, where the laws for exceptions to copyright are much more restrictive, and much of what is taken for granted in how we use the internet, such as using search engines, are actually illegal under many countries' laws, strictly speaking. Okay? Now, secondly, in India, we have things such as the Gundas Act, which people in Bollywood and some regional film industries, as well with the support of the MPA, have actually pushed for video piracy to have to be dealt with under this thing called the Gundas Act, which allows for preventive detention. Preventive detention is something that was used against Indian freedom fighters. Okay, is something that is used in repressive regimes where people are detained without having to show cause, without having to produce them before a judge, are allowed to just be jailed. Now, selling CDs by the roadside, I don't think should merit that kind of, that's not even punishment, that is preventing someone from committing a potential crime, okay, on suspicion. Now, and a couple of other examples. Random House, for instance, is now preventing libraries from being able to lend a book more than 27 times. Now, that might sound ridiculous to you, but what if I told you that book is actually an e-book? That is perfectly legal. Random House is well within its rights to do so, even though it can't do so with books. Now, I would like to know how any of this promotes or safeguards access, freedom of expression, privacy, rule of law, and the other kinds of rights that we are speaking about here. And I'd also, so that was the substance question. And I'll quickly add a process one, which is about the discussion happening here at IGF. What role does this discussion actually have on the kinds of discussions that are happening at the TPP trade negotiations, or at when the World Intellectual Property Organization commissions a report on intermediary liability and certain countries are actually pushing for greater action at WIPO? Now, I don't see any governments actually stepping in here and saying, and listening and saying, we're going to take this to the trade negotiation processes. Now, isn't intermediary liability actually an issue of internet governance? Then what is the role of the Internet Governance Forum if it actually can't inform any of those processes? Is it just a mere talk shop which doesn't even actually affect any decisions made anywhere else?
Thank you. So we have a couple of provocative questions here. So I don't know if we can start it by Stuart.
I'll do my best to tackle a few of those. First of all, I think there is definitely a connection between access to knowledge, human rights, and copyright. And in terms of censorship, I think the most classic case that sort of springs to mind is the Scientologists, who have very actively used copyright law to take down material. There's a particularly interesting case this year in the UK where an academic paper was allegedly censored by its publisher, Taylor and Francis, on the grounds that there were some outstanding copyright issues that needed to be cleared up. The paper was held up for about 8 or 9 months and eventually published. But the actual subject of the paper was the increasing price of academic journals and possible corruption in academic journal industry, and the publisher was actually forced to apologize in the end. When they apologized, they cited overzealous concerns about copyright. So I think that's something we need to keep an eye on. It comes up, IFLA monitors that. I'd pick up the TPP. We're very worried about the secrecy around those negotiations. IFLA's on the record with a number of organisations about, how can we get involved in this process? We don't exactly know what's going on. We can't base firm policy just on WikiLeaks. One thing I think is very interesting, this morning reading the tweets about an earlier copyright session, I think there were calls to dismantle WIPO. And whilst that would stop me going from many, many meetings that last until 2 a.m. and never get anywhere, on the other hand, at WIPO, all of us as NGOs can actually access the documents that are on the table and can actually see a lot of the raw material for the discussions. So I think that's kind of an interesting approach vis-a-vis the TPP, which could have some very, very bad impacts, particularly on libraries and countries that don't have the same term extension. We've got librarians in Canada and sort of in other countries working on this. E-books is a huge problem. It's probably a side question of this because there's a lot in there about whether or not we have the right to purchase something and then whether or not we are ever purchasing something as opposed to licensing it. It's kind of interesting that the concept you're talking about there, only 27 loans, is something called friction, because the idea was that after you loan a book 27 times it falls to pieces. And then you'd need to buy one anyway. Any librarian who's ever worked with sticky tape will tell you that's not the case. You can keep it going for quite a long time. Yeah, we can get up to 40, 50 times. So that's a huge problem for us. But I would go more general and go back to the IGF one, because whenever I come to the IGF, and I have been on a lot of the copyright panels, and I really do enjoy it, and I particularly enjoy having dialogue with our colleagues from the entertainment industry, from the copyright industries, and we have very good conversations, and we make very good points, and we listen to each other. And if we meet in the bar, and the same goes in WIPO, we can have very good conversations, very good informal relations, even informal support for some aspects of what the libraries are trying to do at WIPO. The moment you turn up on the floor at WIPO, all of that is out the window. Nothing from those discussions ever make it to the negotiating position. All you get is a stonewall, and there is literally no attempt at being flexible. I kind of understand this as a bargaining position. I fully understand it. It makes kind of perfect sense. It's how I would go into it, I guess. But anything that could be perceived as weakening copyright will go nowhere within WIPO unless you really push and you've got the energy to go for 30 years. The amount of people that said, we never need a treaty for the blind, it's just not needed, we have the existing frameworks, and then those same people, when the Treaty for the Blind cropped up, we've always supported a treaty for the blind, we're very pleased that it's here. Rubbish. So I'm not sure how much the IGF actually affects those sorts of really hardcore conversations.
Thank you. Thank you, Stuart. Peter.
Thank you. I don't have answers to any of these questions. I don't think anybody does, but I can perhaps give you some thoughts on two of them. And the first is the role of the IGF and whether it makes any difference. And the answer is, like most legal questions and constitutional questions, it depends. First of all, it's very important that the IGF not replace other decision-making bodies for all sorts of reasons. And part of the charter of the IGF is to respect and work with other institutions. So your question really is, how do we take it from here and go somewhere else? And I think the bottom line about that is there is no them here. There's only us. There isn't an executive body at the IGF or a set of staff who are going to listen, act as rapporteurs, convert this into a discussion document, and unless we do that ourselves. So you've got to understand that the way the IGF works is that we would need to form a dynamic coalition or one of the other mechanisms that the IGF provides and turn it into something. So it's not, there's no them, there's only us, I guess is the point there. And I think the other point I would come to is most of these questions are directed, it seems to me, at the fundamental question, what is the value, what drives, is the original premise of copyright, or the original understanding that most of us have about copyright, still true, and what aspects of it need challenging? And I think the question about, does it, as people say, incent creativity, and the hint of that in the Bollywood question we got before, which incidentally we haven't had an answer from our Indian colleague to whom it was directed, so that would be interesting. it was not a creation of authors clamouring for rights. It was done by distributors, and the thing the internet has changed mostly is the mode of distribution. So this is the kind of debate we have to have. What are the fundamental underpinnings, and have they changed? I think they have, and I think we've got to have that debate.
Thank you. We have one tweet for Konstantinos. One tweet.
Yes. Just going back a little bit to the IGF and the role. Yes, Peter is right. We don't want to turn the IGF into a negotiating platform. And I think that I will disagree with Stuart on the influence that it has had. First of all, look at this room. We are all together because of the IGF to discuss all these issues. And going back to WIPO, I think, you know, I followed as well the negotiations for the Marrakesh Treaty, and gradually and over the years we were getting our hands on the text, even if it was at 2 a.m. in the morning, and even if we had to stay at 5 a.m. until 5 a.m. to get our heads around it, we were still getting and we were knowing what governments were discussing. And sure, there are other venues where this is not happening, and we cannot possibly be expecting that everything is going to happen at the same time. What I'm trying to say is that I don't think that we would have gone there if it wasn't the IGF to support this, this idea of bringing everybody together to discuss and providing, if you want, the forum to do so.
Well, following the discussion, Linda.
So I just wanted to address more broadly, one thing that has always baffled me is the movie industry really is founded on the premise of free expression. Developing movies is about telling stories, and there are a lot of stories in life that are painful, and there are a lot of stories that maybe don't flatter a government or a certain ethnic group or whatever the issue is. So you're not always going to have stories that agree with your point of view. But at least in America, the entertainment industry rests on free speech. And we are, in fact, the defenders and aggressive defenders, and bring cases to the Supreme Court defending, again, our right for free speech. So I've never quite understood how this concept that copyright is somehow in tension with free speech, when that is the absolute fundamental foundation of the entertainment industry. And we met with another group. A great thing about IGF is there are so many different groups here, and all of us are brought together because we all want a better online environment. And we met with the group from Freedom House as a delegation of people from around the world, all of them focused on free speech. Again, their whole mission here, they don't know the first, I mean, most of them don't know anything about copyright law. They know about free speech and that in their country it is repressed. And we had so many things in common talking to those people in those countries. So I think what we have found is that in countries where there is a tradition of free speech, there also tends to be strong copyright, and it allows industries like ours to tell difficult stories that perhaps others want to censor. And that's why I think it's important that those two themes go together.
Thank you. So, do you have another tweet? No, right? Okay, great. Michi then.
Just one quick comment about the fact of copyright law. In the United States, the justification always for copyright law which has been given is the balance is two things. One is the fair use, and the other is idea-expression dichotomy. And it has mostly been said, and courts have usually justified and evaded the tough question about the censorious powers of copyright, and say that copyright law balances the First Amendment concerns because it has these two big concepts built in. However, despite being the most widely used example of a content-based regulation, copyright cases almost never invoke First Amendment scrutiny. Courts issue regular injunctions, which are prior restraints in copyright cases before any evidence actually comes into a court. The question about IGF being a forum, I don't think I am well placed to answer. It is the right question to raise, why all of us are here and debating these things, and what is the outcome of all this discussion, and where do these inputs really go if these back alley, on the side, various treaties between this continent, that one, and now you are at this conference, we are going to already start this discussion. And having all of these in separate silos is not going to serve any purpose. And we could all keep talking ad nauseum and not go anywhere. So I do not know what is the purpose. It's definitely an enriching discussion. I agree absolutely that we hear so many viewpoints, we understand what other people are thinking. It also gives us ideas about our own works, but I can't comment anything about the outcome. But unless we have a comprehensive way to address these questions, then having all this one conference to the other, it's just going to add miles for everybody's airlines record, and that's about it. One thing I do want to say is, which I agree with Stuart, the Net Mondial, which has been hailed as this biggest success story, it was a great success. It broke new grounds about bringing together many people and engaging in a very something which had never been done and involving a lot of people remotely, etc. But it's not for panacea. It wasn't perfect. There was a lot of problem. But if you see the number of comments about intellectual property rights in the document, and the insistence about addition of the word, the respecting the rights of not just authors, but creators as established by law, it will tell you how all of this plays out into the real world. The study, I believe, was in Nigeria and not in India of Bollywood, but maybe I'm mistaken. So I do not know exactly which.
I can say something.
Yes, please.
So because I did the local content paper, so the study you were referencing wasn't Bollywood, I don't think. It's yeah, it's Nigeria. So I actually don't think we have that question answered, and I'm still very interested in that question.
There is in fact a 2014 Harvard article that appears to make the opposite point.
I've got it here. Yeah.
Can you pull it up? Because does anybody else have access to that?
Yeah, I can get it up for you. No, it's not.
When arguments get resolved by facts, isn't it?
I'll just search the word.
Claudio, Twitter wants to know that as well.
I don't know if we have some remote participation questions.
No, we had lost connection earlier, but people, I tried to follow the discussion on Twitter, and everyone is asking the same thing about this report. Okay. So we want to read it, see if it exists. There is another question, but do you want to share it, or there's not another question? Yeah, there is just one question that it's if let's see if I can formulate it properly.
Yeah, these are comments.
Oh, I think I lost it. Okay, here it is. If there isn't a conflict between copyright and free speech, then surely locking away content means that this content is not going to be part of the conversation. It's not going to be part of what constitutes free speech.
Okay, we're running out of time, but we will have another round. If you wanted, Stuart, ask for the word.
Yeah, I wanted to say just another thing about the censorship angle, because one thing I didn't mention in my response is perhaps the more worrying aspect of this. And I think when copyright's going to get really caught up in censorship, it's going to be as a result of automation and takedowns as a result of algorithms. And that's when we do move into an area where humans aren't making the decisions. Often, perhaps, shall we say, the algorithms to take down the content may have been influenced at certain points by industries who really want that content taken down. And I understand that Google gets millions of takedown notices every period, every day, whatever it is. But I mean, some stuff caught up in that, I would wager, is not going to be. infringing copyright. So I think that there's a real danger as we move on in relying too much on automation that we can be overzealous in this, and that to me is going to be a long-term problem we need to solve.
Linda.
Sorry. So here's the reference to the study. It is Bollywood Piracy and New Product Creation, a Bollywood story. It's by Raul Talang from Carnegie Mellon and Joel Waldfogel from the University of Minnesota, and they look at the Indian market.
Can I provide another citation?
Sure, we can discuss it further. I don't know if any other panelists has some closing remarks? No? Oh, we can talk for weeks about copyright, but no, we don't have more comments. Okay, thank you everyone. Thank you my panelists. It's been a great discussion, and I hope we enjoyed. So thank you.
Thank you.
Yeah, I was.
But then I apologise. I was looking at the Nigerian thing.
It's the size of the Bollywood
I
study.
still don't think we answered the question, though. I mean, if the US are saying that production will massively increase if IP protection is increased.
Who's saying that?
Well, that was what the gentleman said. See, I want to answer the question. I'm not saying that I know the answer. I want an answer to the question.
No, I thought he was comparing the U.S. production, the number, to the number in India.
He was saying
which, by the way, there are more people in India. There are more. I mean, the quality of their productions are different. I mean, that's.
No, but I'm not sure it was related with copyright.
No, he was saying, if I read him correctly, and again, I'm only looking for an answer. He was saying that the US was lambasting India for not having enough IP protection, and if they had more IP protection, they would have even more content out.
And that's what this says.
But
it says that when they reduce piracy, the creative output increased.
Okay, well I'm going to read that report because it seems to me that...
that's the premise of the study. So I was only quoting the data.
Oh, definitely.
I was only quoting the data that is presented in the study.
I think I need to see his thing as well, because his point would be, well, I'd need to see how exactly you're going to get from like 1,400, did he say, a year, up to something that would be considered a drastic increase. I mean, what would a drastic
I don't understand. He doesn't have imperial data. I mean, he doesn't have data to support what he's saying.
I think he's saying he does.
He said he does, yes.
That somehow, if you increase enforcement, you're going to reduce creativity? You're going to reduce the number of creative products? That doesn't make, I mean, no producer will ever say that. That's not...
No, I mean, that's the fundamental question at the heart of all of this, isn't it? You'll find some people on one side of the debate saying if you reduce enforcement, you'll increase creativity.
Right, but what I think is interesting is, for the first time they have a data set.
Well, he says he has one's work, so I want to see...
He was referring another one, maybe.
No, I believe fully in weighing up which one goes with.
So thank you.
Yes.
It was great.
Good. Thank you for organizing.
I had a very good question. My name is Monis.
I'm now going to go to another workshop.
Yes. Although in my former job more so than now.
Okay. I'm the chairman of the Web Payments Group.
Where are you up to now?
I have another meeting up
Well, I'll send you an email.
Oh, definitely.
I'm joining. Thank you. I enjoyed it.
Thank you. Was great. Thank you.
Well, the uniform system. The idea here is
So that's a very fair point. I got that wrong. But if he says he's got the term data, then I
DC, so we should get it.
Okay, yes, okay. Nice to meet you.
Sorry about that. I just saw that one. You were absolutely correct about the study. We're going to go and read it. Right? No, you're absolutely correct. You're going to tell the gentleman that it's what you just said.
Yeah, no,
And pleasure to meet you.
Yes, very nice meeting you.
Yes. You're in DC and I'm in New York. Sometimes probably we'll get to see each other.
Okay.
work with The clown who used to be the president of my organisation. I know her very well. She's really enjoying her time.
That's why everything we're ITF. So we're more involved in the technical side.
So he is actually in our Silicon Valley office, and he is an engineer, and he also is on IGF.
You wouldn't happen to have his email?
Yes. So this is wonderful to make sure it's not. So my name is Linda Kinney. You said that you met me.
No, she's really good.
Good idea.
And also, I think
I would refer you to him. He is working on technical standards and the person in IGF. He's our FPA contact.